नमस्कार, वेलकम टू योर ओन चैनल कानूनी चर्चा। आपका स्वागत है दर्शकों। कानूनी चर्चा चैनल में, ये आपका अपना चैनल है। हमने आपको ये जानकारी है, पता है कि हम कानूनी चर्चा जो करते हैं, एक लॉ सीरीज हमने प्रोग्राम बनाया हुआ और डिफरेंट कानून, डिफरेंट एक्ट्स, लेजिस्लेशन जो कानून के हैं, पार्लियामेंट के एक्ट्स हैं, उस पर डिफरेंट एक्ट पे हम बात करते हैं। तो पिछले दिनों हमने हिंदू मैरिज एक्ट शुरू किया हुआ है। तो मैं आज बात करनी थी, मैंने सेक्शन 16 पे, जो लिस्टिमेसी ऑफ द चिल्ड्रन born to the couples whose marriage is either void, nullity in the eyes of law as per section 11 or voidable as per section 12 of the हिंदू मैरिज एक्ट। लेकिन आज मैं थोड़ा सा इसमें थोड़ा सा हट के, इससे पहले, क्योंकि ये जो लिस्टिमेसी ऑफ द चिल्ड्रन है और जो मैरिज का कॉन्सेप्ट है अमंग हिंदूज, तो आज इसका थोड़ा सा सेकुलर करेक्टर, और आज जो हमारा समाज है जो अवॉल्व हो रहा है, जो हमारी सोसाइटी अवॉल्व हो रही है विद द जो मॉडर्नाइजेशन आप कह लो, इसका अफेक्ट हो रहा है, वेस्टर्न इफेक्ट आप कह सकते हो, जहां पे सुप्रीम कोर्ट की जजमेंट्स आनी और लोगों का जो बच्चे ने जो शादी की एज में पहुंचने से पहले, मैरिज एज के पहले, एडोलसेंट एज में, हम कह सकते हैं कि वो कहीं तो वो एक चाहते हैं कि मैरिज से पहले हमारा रिलेशन, जैसे आप आज जानते हो, ये मेरा बॉयफ्रेंड है, ये मेरी गर्लफ्रेंड है। तो ये जो कॉन्सेप्ट है, जो ये अवॉल्व हो रहा है सोसाइटी, जो मॉरलिटी आज आप इसको अपग्रेड हो रही है, जैसे भी आप इसको समझ सकते हो, और ये कॉन्स्टिट्यूशनल मॉरलिटी तक जा रही है। और हमारा तो कॉन्स्टिट्यूशन है, संविधान है, तो हमने देखना है कि सोसाइटल मॉरलिटी किस हद तक जो अवॉल्व हुई है सोसाइटी में, मॉडर्नाइजेशन जो आया है लोगों में, सोशल जो प्रैक्टिसेस हैं, नॉर्म्स हैं, जो हम अभी अडॉप्ट कर रहे हैं, क्या इसकी मान्यता एक तो समाज करेगा पहले, और क्या हमारा संविधान करता है या कि नहीं। ये आज मैं जो टॉपिक है मेरा, जो मैरिज के रिलेटेड है, मैरिज जो लिव इन रिलेशनशिप में। अभी मैं ये टॉपिक क्यों उठाया मैंने, लिव इन रिलेशनशिप, तो जो पिछले दिनों, अभी चंद ही दिन हुए हैं, 2-4 दिन पहले की बात है, कि इलाहाबाद हाई कोर्ट में एक कपल आ गया। उन्होंने रिक्वेस्ट की, प्रेयर की हाई कोर्ट ऑफ इलाहाबाद में, जिसके हमें प्रोटेक्शन दी जाए पुलिस। और जो लड़का था वो माइनर था, वो लड़का जो मैरिजेबल एज एज पर हिंदू एक्ट, मैरिज एक्ट, ठीक है, लड़के की 21 ईयर्स होने चाहिए और लड़के की 18 है एज पर सेक्शन 5 ऑफ हिंदू मैरिज एक्ट। लेकिन एज ऑफ मेजॉरिटी कह सकते हैं हम, जो हमारा 18 ईयर्स से बिलो अगर लिव इन रिलेशनशिप में नहीं रह सकता, क्यों एज ऑफ मेजॉरिटी जो है, ये कंसेंट लिव इन रिलेशनशिप के लिए एक जरूरी है, नेसेसिटी है। तो इसलिए जो मैं आज बात करने जा रहा हूं, तो इस इलाहाबाद के जो जजमेंट या ऑर्डर आया, जिसमें उन्होंने 482 के नीचे क्रैश करने के लिए, क्योंकि जो लड़का था ये उसके खिलाफ एक FIR रजिस्टर्ड हुई है 366, क्योंकि जो लड़की थी वो मेजर थी, जो उसकी लिव इन रिलेशनशिप पे कह सकते हो या गर्लफ्रेंड थी, जो भी आप कह सकते हो। तो उसको क्रैश करने के लिए ये इलाहाबाद हाई कोर्ट में गए। तो इलाहाबाद हाई कोर्ट का ये है, इसका टाइटल है अंचल राजवर, ये लड़की है, और जय हिंद राजवर जो लड़का है। तो पुलिस प्रोटेक्शन मांगी और क्रैश के लिए इन्होंने कहा कि हम दोनों रह रहे हैं, और जब लड़के की एज जो है बराबर हो जाएगी, मैरिजेबल एज जो भी है 21 लगा लो, या मेजॉरिटी गेन कर लेगा 18 ईयर्स तो हम मैरिज कर लेंगे, इन बिटवीन हमें प्रोटेक्शन दी जाए। और ये जो FIR की है लॉज ये गलत है 366, लेकिन कोर्ट ने कहा कि ये माइनर है। हॉनरेबल हाई कोर्ट ऑफ इलाहाबाद उत्तर प्रदेश ने कहा ये माइनर है, तो इसको कहाँ अधिकार है लिव इन रिलेशनशिप का। और स्पैन भी बड़ा कम हुआ था उनका, दोनों का जो लिविंग रिलेशनशिप में थे वो 2 मंथ आई थिंक वो पीरियड था। तो इसलिए इसको मद्देनजर रखते हुए तो वहां एक इन्होंने जो ऑब्वियसली जो कपल जो था इन्होंने किया कि आर्टिकल 21 पर्सनल प्रोटेक्शन देता है, पर्सनल लाइफ को प्रोटेक्ट करने के लिए और डिग्निफाइड लाइफ देनी, तो हमें प्रोटेक्शन प्रदान की जाए फ्रॉम, और स्टेट हमें इज अंडर लीगल ऑब्लिगेशन टू प्रोवाइड अस। एज हमारी कम है, ज्यादा है, इस इररेलेवेंट है फॉर इन्वोकिंग आर्टिकल 21 बाय द हॉनरेबल हाई कोर्ट ऑफ इलाहाबाद, बट the Honorable High Court of Allahabad did not agree and dismissed their petition. So now a similar situated case has come before Punjab and Haryana High Court. This is as on the I think a recent about a week or week back. That is that they were also living in a relationship, but boy was not of a marriageable age. इनके marriageable age you can say 18 years if we do not go to section 25 of this Hindu Marriage Act. So in Hindu Marriage Act, a male is required to be of 21 years and female bride is required to be 18 years. Bridegroom here was below. They were living in relation. They also sought the protection from the Honorable High Court of Punjab and Haryana. What happened? Thereafter, however, here in this case, the Punjab and Haryana High Court has granted protection. They have expanded the jurisdiction by invoking Article 142, this article, this article, you may say Rtd jurisdiction, and by exercising Rtd jurisdiction, they have directed the state police to protect the couple. No doubt they have not attained the age of majority, but the court is not concerned. The Constitutional Court is not concerned with the age of the couple. Only consideration for the couple, for the Honorable High Court, while exercising jurisdiction under Article 21, is to see by their human rights. There is a violation of Article 21. By that they requires protection. By that the couple, the life civil union is being disturbed by anyone, then on that ground, now it is up to by this order of the order of the Punjab and Haryana High Court is in consonance or is in law, is in accordance with the earlier judgment of Supreme Court of India. Now, but law evolves. This judgment of the Supreme Court, this judgment of the Punjab and Haryana High Court may be upheld by the Supreme Court of India, because Supreme Court also evolved by exercising its jurisdiction, or particularly under constitutional, but particularly in Article 21 while dealing with these fundamental rights, or there is a large scale extension of the Article 21, you might be knowing, of the Constitution by the Supreme Court of India in their recent judgment and earlier judgments. So now my concern is that there is two judgments, one of Allahabad High Court, where protection was not granted to the couple, where one of the party, here the male in Allahabad High Court was not granted protection by the Allahabad High Court, but in another case before this Punjab and Haryana High Court, the protection was granted to the couple. In this case also, the male partner was also minor. But now we'll see what would be the fate of these two judgments when these judgments would go, when assailed before the Honorable Supreme Court of India. Let us now come to different judgments of the Supreme Court of India, which on the basis of which this live-in relationship has recognized, not legally recognized. Now there is no law or rule available in India which recognized the live-in relationship obviously between two adults of opposite sex, not legally, but it is also similarly in the opposite. You may say it is not declared or considered as illegal, unlawful, or any offense of this is there when two adults live together, live in together. Now, earlier there are many judgments of the Supreme Court which have recognized the living of a couple, male and female, under single roof and performance of all the marital relationships, even in absence of the formal marriage. This what this live-in relationship is. Everything is there as per the Supreme Court, but law has evolved presently in India. Both the male and female should be two adults. They have already attained the age of majority for solemnization of marriage. One thing, obviously they should not be of unsound mind, and other conditions which are provided in section 5 of the Hindu Marriage Act, and similar in, you may say, in different acts, different personal laws of under Muslim Act and some other acts, because where there is no codification, where of the laws and personal laws are applicable. There may be to the Muslims, now their marriage is solemnized as per their own personal law. But this is secular character the Supreme Court has recognized. Now, one thing I will add. Now, this no doubt this I have already stated, and now I want to reiterate. Now, this type of relationship are not still in our traditional society recognized by our elders, by our society elders, but societal morals have evolved now. They are going towards the constitutional moralities, and that is to be followed, adopted practices, and Supreme Court, as per the constitutional mandate, are providing protections, are considering protection of the protection under Article 21 is to be granted in order to save their continuity of the relationship. Obviously, no one should put them to fear. Should deal with them this physically and mentally in violation of certain laws. You can say also by where there is an apprehension of commission of offence against the couple by anyone, including the parents, including the society. You might be knowing there are cops, there are village elders who decides, and who 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 do not recognize such type of marriage, but they according to Supreme Court directions, High Court direction, they are bound not to interfere into their matrimonial lives, who are live in a relationship, and they should not be any sort of torturing, this misbehaving, or otherwise committing of any offense against them under relevant provisions of Indian Penal Code or some other offense. They should not be, they should, because Article 21 provides everybody, the couple living in a relationship have also to have a dignified life, marital life. How they can be, their life can be interfered in violation of. Under these considerations, the Supreme Court of India has recognized the live-in relationship couples and protected them, their relationship from being interfered in any manner, mentally, physically, by anyone, in any manner, by anyone, parents, in-laws, or by any person of the society. This is what I have studied and I have seen with regard to this live-in relationship. Now question arises. Now, what would be the fate of a wife or husband who are living in a relationship, who have not formally solemnized their marriage? What would be fate of if one of them dies? So law recognizes that right of inheritance is available to the leftover couple. If the husband dies, if the male partner dies, female has a right to inherit his property. If the vice versa, if the male dies, the female has a right to inherit the property. He is entitled to all rights whatsoever is available if they have been married formally in accordance with the relevant provisions of Hindu Marriage Act, or according to their personal laws, or according to their customary laws. I go to that extent. Then this is with regard to inheritance of the property. A law of inheritance equally applicable to the live-in relationship partners. Now, what would be the next question is, how would their child would be treated in society? No doubt, the society do not recognize such a child. This on moral grounds, but legally speaking, law has evolved now that they are considered. Just I have same is the status of the child which is available to the child of widowed and wide marriage under section 16 of Hindu Marriage Act, which we have to discuss in detail in next episode. Now, this is same children are considered legitimate of the couple who are living in a relationship. Now, this is with regard to no question arises whether a wife is entitled to maintenance under this Code of Criminal Procedure. The relevant section is 125. After coming a report of Malimat Commission, the provision was added that wife, the female wife, word wife is not proper, the female partner can claim she has been included now in the definition of the female partner in live-in relationship is included in the definition of wife under this section 125 of Code of Criminal Procedure. Now, she is considered as a party, as a male. She is in broad terms would be considered as a wife. Female partner in live-in relationship is included in the definition of a wife. And if she, then there is she has got a status of wife by in her inclusion in definition of the wife under this section I have referred earlier. Then obviously she is entitled to maintenance, monthly maintenance. Now this is now it is clear that female partner of live-in relationship is, if she is deserted or otherwise not kept in marital relationship by or otherwise avoided, she is entitled for maintenance. Similarly situated grounds are available to him, to her also, as are available to a former wife. Definition of wife. She is. Now, next question is similar. There is a Domestic Violence Act. There is a definition under section 2F, I think. There is a definition of the wife also. So then, under this definition also, the partner, female partner, who's in live-in relationship is also regarded as entitled to all the protection which is available to a wife under this Domestic Violence Act. Now it is also she is entitled to the live-in relationship. The female is entitled to maintenance, right of inheritance, child or consented legitimate, and entitled to this inheritance. Now I will there are important judgments of Supreme Court. I read out some important judgments now of the Supreme Court which have recognized the live-in relationship between two adults, obviously opposite sex, male and female. They are. This is also recognized as legal. No doubt, it is not recognized. There is no legislation, Parliament Act, which gives wherein these relationships are considered as valid. But simultaneously, the couple living is not committing any offense. Their relationship is not considered as illegal because they are adults, and adults have a right to do anything. They have a personal rights under Article 21 of Constitution of India to lead life their own according to their own choice, including marital relationship. These therefore the Indian law now some judgments are these are judgment of, there is a judgment of Khushbu versus Kanooni Charcha. The Supreme Court held, now I will read out whatsoever is available with me in very short note of the judgments. The Khushbu versus Kanooni Charcha with regard to live-in relationship. Main consideration of this judgment is on the basis of the Article 21, protection of personal life. The Supreme Court held that a living relationship comes within the ambit of right to life under Article 21 of the Constitution of India. The court further held that live-in relationship are permissible and the act of two major living is the majority together cannot be considered as unlawful or illegal because it is neither a matrimonial offense nor it is a offense under Indian Penal Code. Next case is Gurvinder Singh and another versus State of Punjab and others. In the leading case of Punjab and Haryana High Court, it was observed that live-in relationships are morally and socially not acceptable. This is observation. The petitioner couple moved to High Court seeking direction to Punjab police to grant protection from their families. The case was heard by a single judge bench of Justice H.S. Madan, who turned down the plea by the petitioner, who also expressed that they intend to get married soon. This is a judgment of, now earlier judgment was of Supreme Court of India. Now there is a judgment of High Court of India, which has High Court of this state of Punjab and Haryana. It has not recognized such a relationship and not granted and dismissed the petition of the petitioner. Indra Sharma versus B.K. Sharma, Supreme Court laid down the condition for live-in relationship that can be given the status of marriage. Now, the Supreme Court in this judgment has recognized the live-in relationship and given them the status of a marriage. They are considered as equally situated as if they have solemnized marriage. Indra Sharma versus B.K. Sharma. Now, there is a judgment, landmark judgment of Dannu Lal versus Ganesh Shram. The Supreme Court decided that couples living in, this is very interesting, living in relationship will be presumed legally married. This is a presumption as done because they were living for quite some time under single roof and performing all the marital relationships. As husband and wife, they were considered as if this marital status was considered as husband and wife. Held that women in relationship would be eligible to inherit the property. Now, question I have already said that such a female partner is entitled to inherit the property of the male partner after his death, after the death of her partner. This is what another case is with regard to this is now a one. There was a judgment, and now this judgment is related how the Supreme Court of India had considered and invoked Section 144 of Evidence Act regarding presumption and non-presumption. SPS Bala Subramaniam and Surtu Narayan. This is a case title. The Supreme Court of India held if a man and woman are living under the same roof and are cohabiting for some years, there will be a presumption under Section 114 of Evidence Act that they live as husband and wife and children born to them will not be illegitimate. Similar, such I have referred to Section 16 of Hindu Marriage Act. Their children are considered of such a couple who is living for quite some time and performing all the marital relation as a husband and wife. Their children are considered as legitimate children. I think the similar status has been given to such children as were available of the marriages void and voidable under Section 14. If the marriage is in violation of Section 11, there is a nullity marriage, the status of the children would be legitimate, and similar is when there is a voidable marriage declared by a court or law, family court, then their children also considered, children of that marriage also considered as legitimate. this is this is with regard to legitimacy of the this born children to such couples. This is another judgment of Bharta Matha versus R. Vijaya Ranganathan. Supreme Court of India held that child born out of live-in relationship may be allowed to inherit the property of parents and therefore be given legitimacy in the eyes of law. This is also similar situated with the main consideration is in these judgments. The Supreme Court has taken the view that what is the fault of the child? What is the fault of the child if something which is not allowed by the society has done by the parents, if something immoral they have done, but the innocent children will get a suffering. So they have the law, the Supreme Court has evolved, and the viewpoint with different judgment, and now there is a law declared by Supreme Court of India that they are considered as legitimate children of such a couple and they have a right of inheritance. Now, I think today it is sufficient for me to, I have touched because I thought that when we are going to discuss about Hindu Marriage Act, it is obviously for us that we should also delve upon the present viewpoint, what Supreme Court is taking and what High Court is taking in different judgments of their. So I have considered it proper to refer here the relationship, live-in relationship. What would be the live-in relationship? How it is considered in our society, and what our law court says about this live-in relationship, and what would be the fate of the children, what would the fate of the couple regarding to inheritance, legitimacy, and when there is a desertion, what would be the how the female partner would be dealt with and has to take benefit of the relevant provisions of under Criminal Procedure Code and Domestic Violence Act. This is all today. Now while my next episode, I think, would be with regard to this LGBT and this same sex whatsoever has evolved in the. I will decodify the Supreme Court judgment in LGBT and this queer couple. Now next I will take that, because it is also related to marriage, because these LGBT people, lesbian and gay people and transgenders are also have wanted and laid their claim that they should also be allowed to solemnize their marriage, and and special for they have also approached the court for invocation of this Special Marriage Act and all this. I will see how the next topic we will also develop on this judgment of the Supreme Court of India, same-sex marriages. Okay, thank you very much.